Something important's been happening inside the Department of Justice. Over the past year, changes at DOJ have significantly eroded safeguards that protect prosecutorial independence. Those safeguards exist for one reason: to ensure that the law is enforced fairly and consistently, regardless of who holds power. What we're seeing now isn't one isolated incident. It's a series of decisions that taken together reveal a pattern. In this video, I'm going to walk you through 5 recent changes inside the Department of Justice that illustrate that pattern and should concern every American. They aren't the only changes that raise concern, but they're among the clearest examples of the shift we're seeing. I retired at the end of September after serving as a federal prosecutor for 30 years. During my career, I supervised prosecutors, helped approve indictments, and served as DOJ's representative at U.S. embassies in Africa and Central America. I lived the institutional culture at the Department of Justice for 3 decades, so the changes we've been witnessing during the past year are obvious to me and deeply troubling. Let's start with prosecutorial charging decisions, because this change has been impossible to miss. During the past year, there have been several highly publicized attempts to pursue criminal charges against critics of the president. Most of the time, the public can't see the evidence prosecutors rely on when they seek an indictment, but there are 2 recent cases where we can evaluate the evidence ourselves because it's entirely public. The first involves the indictment of former FBI Director James Comey. Unlike the next example I'll discuss, this case actually resulted in a federal indictment. Comey's been a prominent critic of President Trump for years. In September of last year, President Trump publicly called on Attorney General Bondi to pursue charges against Comey and others and instructed her to do it now. But inside the Department of Justice, at least one senior prosecutor reportedly refused to go along. The acting U.S. Attorney Eric Siebert resigned or was removed after being pressured to pursue an indictment against Comey that his office reportedly believed was not supported by probable cause. Shortly afterward, at the request of President Trump, Attorney General Bondi appointed Lindsay Halligan as interim U.S. Attorney. She'd never prosecuted a criminal case. Within days, she sought an indictment of Comey on the theory that he made materially false statements in testimony before Congress. I watched that testimony. Everything Comey said during his testimony was literally true. Under the Supreme Court's decision in Bronston v. United States, a literally true statement can't form the basis of a perjury or false statement prosecution. As someone who reviewed charging recommendations for U.S. attorneys for years, I can understand why Mr. Siebert reportedly refused to pursue the case. But a court never had to decide that issue. The indictment was dismissed after a federal court ruled that Halligan's appointment as interim U.S. attorney was unlawful. And the Comey indictment wasn't an isolated episode. Another example involved a reported attempt to indict several members of Congress. News reports indicate that federal prosecutors attempted to charge Senators Mark Kelly and Alyssa Slotkin, along with several members of the House of Representatives. Their alleged crime? A video reminding members of the military and intelligence communities that they must not obey unlawful orders. President Trump called the video seditious behavior, suggested it was punishable by death, and called for the arrests of the lawmakers. Jeanine Pirro, the U.S. Attorney for the District of Columbia appointed by President Trump, reportedly attempted to accommodate him. Regardless of whether someone agrees or disagrees with those members of Congress said, the question a prosecutor must ask before seeking charges is not whether speech is controversial. The question is whether the Constitution allows that speech to be treated as a crime. The Supreme Court answered that question more than 50 years ago in Brandenburg v. Ohio. Under that decision, speech can't be punished as a crime unless the government proves 3 things. First, the speaker intended to incite lawless action. Second, the lawless action was imminent. Third, the speech was likely to produce the lawless action. That's an extraordinarily high bar, and it exists to protect political speech. I've watched the lawmakers' video. You can watch it yourself. The lawmakers encouraged obedience to the Constitution, not disobedience. This isn't a close case. A federal grand jury reportedly saw this for what it was and refused to indict. And federal grand juries indict in the overwhelming majority of cases presented to them. When a grand jury refuses to indict, it means a majority of the jurors believe there's no probable cause to charge a crime. And that matters for another reason. The rules of professional conduct governing prosecutors prohibit pursuing criminal charges that are not supported by probable cause. That rule exists because the power to accuse someone of a federal crime is one of the most extraordinary powers the government possesses. It has to be exercised within constitutional and ethical boundaries. When you step back and look at the Comey case and the Kelly-Slotkin case together, a troubling pattern emerges. Increasingly, key decisions inside the Department of Justice appear to be driven not by the independent judgment of career prosecutors applying the law and the evidence, but by political loyalty and pressure from the top. And that brings us to the second change inside the Department of Justice. That change involves who's exercising prosecutorial power inside the department. The Constitution requires Senate advice and consent for appointment of United States attorneys. Congress reinforced that safeguard in 28 U.S.C. Section 546. Under that law, the Attorney General may appoint an interim U.S. Attorney for 120 days. If the Senate hasn't confirmed a nominee when that period expires, the District Court appoints a U.S. Attorney to serve until confirmation. Congress created that mechanism for a reason. It ensures that a president can't indefinitely control federal prosecutorial leadership without Senate confirmation. Over the past year, Department of Justice leadership has attempted to circumvent that safeguard. Federal courts in at least 4 districts concluded that interim U.S. attorneys were serving unlawfully. In one case in New Jersey, that ruling's already been upheld on appeal, and some prosecutions were dismissed because of those unlawful appointments. In recent weeks, 2 court-appointed U.S. attorneys, one in the Northern District of New York and one in the Eastern District of Virginia, were removed within hours of their judicial appointments. That's highly unusual. Historically, court-appointed U.S. attorneys serve until a president's nominee is confirmed by the Senate. When court-appointed prosecutors are removed almost immediately after appointment, it undermines the very mechanism Congress created to prevent indefinite executive control over federal prosecutions. Advice and consent isn't ceremonial. It's a structural safeguard designed to ensure that qualified individuals exercise the extraordinary power of federal prosecution. Another troubling change involves the removal of experienced career prosecutors. For decades, the Department of Justice has relied on a merit-based civil service system designed to prevent prosecutors from being removed for political reasons, a principle reinforced by the Civil Service Reform Act. But over the past year, we've seen departures from that. For example, Maureen Comey, a highly respected federal prosecutor who helped bring Jeffrey Epstein to justice and successfully prosecuted Ghislaine Maxwell, was fired. The apparent reason? She's the daughter of James Comey. Other prosecutors associated with politically sensitive investigations, including cases arising from the January 6th attack on the Capitol, have also been removed or pressured to leave. When experienced career prosecutors are removed for political reasons, the signal's unmistakable. Independent professional judgment based on law and evidence is no longer a reliable guide for prosecutors deciding what cases to bring. Another change involves pressure directed at private law firms. The president issued executive orders targeting firms that represented perceived political enemies. Those orders stripped security clearances and restricted access to government business. The Department of Justice defended those orders in court, and federal judges expressed alarm. One federal judge said in open court that the orders sent chills down her spine. In a written ruling, she described the orders as an attack on foundational principles. In a constitutional system, lawyers have to be able to represent unpopular clients, including critics of the government. When government power is used to pressure law firms based on the clients they represent, the chilling effect extends far beyond any single case. The final change involves direct intervention by department leadership in prosecutorial decisions and the weakening of internal safeguards. In one high-profile example, at least 7 federal prosecutors resigned rather than comply with leadership directives to dismiss criminal charges against former New York City Mayor Eric Adams. In another situation, at least 6 prosecutors in Minnesota reportedly resigned after leadership declined to allow investigations into the controversial killing of Renee Good. At the same time, ethics professionals inside the department, the people responsible for ensuring compliance with professional rules, have been removed or sidelined. These offices exist to ensure that prosecutors follow the rules that govern their extraordinary power. When those safeguards weaken, the risk is not simply that a few cases are mishandled. The risk is that prosecutorial power itself begins to serve political interests rather than the rule of law. Before ending, let me say something important. This commentary is directed at the politically appointed leadership of the Department of Justice. It's not a criticism of the extraordinary men and women who serve inside the department. The career prosecutors, civil attorneys, investigators, and law enforcement professionals who continue to serve the public with integrity every day. But institutions are defined by how power is exercised at the top. When loyalty-driven decision-making replaces independent prosecutorial judgment, the character of the institution changes. The Department of Justice doesn't belong to a president. It belongs to the American people who deserve fairness and consistent application of the law, regardless of who holds power.